Hello again, everyone. I didn't expect to be here again quite so soon. Yet here we are. This is just the way the day has gone. So we've got a monumental new court filing in the Delphi case. We've not done court filings for a while on this channel. At one point, we were doing this like almost every day, reading new court filings in Delphi. But since the trial, you know, it's been a big waiting game. And this is the first thing we've been waiting for. This is the motion to correct errors that happened in the trial. So this is the first stage, I guess, in the appeals process. So there's a 24-page document plus a bunch of exhibits. So we're going to go through it all. There's even a couple of videos. So the defense is laying it all out there. And it's very, very, very interesting. And it reveals some multiple, not just errors, lies. Quite frankly, lies that the state absolutely 100% knew about. This is beyond the shadow of a doubt proof beyond any reasonable doubt, any and all reasonable doubt that the state knew that what they brought to the jury was lies. So we're going to get into it. We're going to get into it all. We're going to be doing some reading. We're going to be doing a little bit of watching. I'm going to say a couple of hellos, though, but we've got Holly. Hello, Holly. No, sadly not. No more news on Eliza and Henrietta from Aberdeen in Scotland. No, they're still missing. The cops are still searching the river. There was a little bit of a news piece yesterday saying that they were searching the harbour with some photos. But no, they're still missing. Hello, CW. We've got RJ Davis. We've got A1 Way Street, Fat Lady Channel, Shazza, Susan, Spider's Lion, Oh Snap Ginger, The Quiet Observer. Oh, I'm a quiet observer. It's the quiet ones you've got to watch. Hello, BGOG. Oh, CW's going doing the horses. Tony, can't solve a lie. Well, what you can do with lies is you can reveal them. You can unravel them. You can display them for all to see. And that's what's happening here. We've got Heather Feather. We've got Kimberly. And we've got Charmaine. And also Birdie's Crime Chat. We've got Corvette Sally. So we got to the end of the chat. All right, we better get into this. We're going to start as we mean to go on and get straight into it. So this is the motion, and as directed by this text, I will be unveiling the exhibits as we go along. So defendant Richard Allen's verified motion to correct errors. Comes now the defendant Richard Allen by counsel files his verified motion to correct errors. For the reasons that follow, the court should either vacate Mr. Allen's convictions. Well, hell will freeze over before Judge Gull would vacate those convictions, or set the matter out for hearing. What are the chances she's just going to go denied without hearing? And don't ask me what happens if she does. Do not ask me. I am very, very unclear on the appeals process. I am relying on others with way more knowledge than I to guide me through the appeals process. All I know is this is the first step, and this is shocking. It's shocking. It's insane. It's insane. And I hope the jurors who convicted Rick Allen are watching. I hope they're watching. The world is watching. I hope they're watching as well. All right. 1. In violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding of November 3rd, 2022. This is proof beyond a doubt that Rick Allen was detained in Westville illegally. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel, and under the United States versus Chronic, 1984, and its progeny, the court should presume Mr. Allen was prejudiced by being unrepresented during that proceeding. So we're going all the way back to October of 2022 and the week that followed. Went all the way back to that. Now, this was Judge Diener. This wasn't Judge Gull. This was Judge Diener at this point. He only recused himself after this safekeeping hearing. So Indiana Code 35-33-11-1 governs safekeeping proceedings for pre-trial detainees and provides in full transfers for personal safety and or safety of others. Upon motion by the sheriff, prosecuting attorney, defendant or his counsel, attorney general or court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death or represents a substantial threat to the safety of others. If the court finds that the inmate is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or to a facility of the Department of Corrections designated by the Commissioner of the Department as suitable for the confinement of that prisoner, and provided that space is available. For the purpose of this chapter, an inmate is not considered in danger of serious bodily injury or death due to an illness or other medical condition. So basically, it's if somebody's going to get to you and kill you, probably, that kind of thing. That's the kind of thing we're looking at. Or if an inmate is so dangerous, they absolutely cannot house him or her in a county jail. Like, it's just too much of a security risk. Like, the guards would be at risk, other inmates would be at risk. You know, you're looking at the most probably serious circumstances here. Indiana Code 35-33-11-2 also governs safekeeping proceedings for pre-trial detainees and provides in full post-transfer hearing, rights of inmate to refuse transfer. The inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse to transfer if the only issue is his pre-trial safety or personal safety. So even if he's judged by the court and judged by the prosecutor to be at risk, if the inmate says, no, I don't care, I want to stay here, that's his choice. I guess it would be different if he was judged a danger to others. That's different. But if it's only his personal safety, well, he can decide whether or not he wants to take that risk, I guess. Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. The next day, October 27th, 2022, Cassie Allen, Mr. Allen's wife, hired attorney Brett Gibson to represent Mr. Allen. Exhibit 1, affidavit of Cassie Allen. Okay. All right, so we go to our exhibits here. And we find Cassie Allen. Here we go. This is what Cassie Allen said. The affiant Cassie Allen, upon her oath under penalty of perjury, says, I am Richard Allen's wife. On October 26, 2022, my husband was interrogated, arrested, and jailed. The next day, October 27, 2022, I paid Brett Gibson, a lawyer in Lafayette, Indiana, $5,000 to represent my husband. Exhibit 1A is an email I received from Mr. Gibson's office acknowledging that I had paid Mr. Gibson to represent my husband. The evening of October 27th, 2022, Mr. Gibson sent a letter by email to the Carroll County Sheriff and Nicholas McClelland, the Carroll County Prosecutor, telling them he was representing my husband and they should cease all questioning of him. Exhibit 1B is a copy of that letter sent to me by Mr. Gibson. About 10 p.m., Mr. Gibson called me to say he would not be able to get my husband out of jail because he was going to be charged with murder the next day. So Kathy got Rick a lawyer on October 27th. All right, so we've got some exhibits here. We've got Exhibit 1A and Exhibit 1B. So if we go back to our exhibits file, Exhibit 1A, all right, okay. So we've got Gibson 5K retainer receipt. All right, so this is the receipt. Payment receipt from Gibson Law Office for $5,000. So this is proof that Kathy Allen paid $5,000 for representation. This was the retainer. Okay, and they obviously quickly realized just how expensive this was going to be once Rick was like formally arrested for murder. She couldn't continue to pay, and that's how Rick Allen ended up throwing himself at the mercy of the court and getting public defenders. So this is how this played out, though. So Kathy Allen paid $5,000. All right, we've got Exhibit 1B. Exhibit 1B. This is a letter to the Carroll County Sheriff. Dear Administrator, please be advised I have been retained to represent Richard M. Allen in certain matters relating to an investigation being conducted by your office. It is my understanding that my client is being detained by Carroll County Sheriff. He will not be giving any statements regarding this matter. If he is currently being questioned, the interview should be terminated. If you've got any comments, please contact me. Brett B. Gibson, October 27th, 2022. Okay. Let's carry on. All right. What emerges from the defendant's exhibit? Oh, okay. All right, we'll read it. In the evening of October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to Nicholas McClelland, the Carroll County Prosecutor, Exhibit 1B, which we've just read. So that was also forwarded to Nick McClelland. What emerges from defendants' exhibits 1C and 1D is the following. Sheriff Leesenby, because remember this wasn't Sheriff Liggett at the time. Liggett was elected sheriff less than a month after Rick Allen was arrested. The timing's interesting. Sheriff Leesenby confirmed receipt of Mr. Gibson's letter by telephone the evening of October 27th. So the sheriff knew that there was a lawyer on board that had been retained. Also on October 27th, over the telephone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McClelland by email, after which Mr. McClelland called Mr. Gibson on his cell phone. So now Nick McClelland is acknowledging that he knows that Rick Allen has an attorney. This is October 27th. This is what, a whole week before the safekeeping hearing. Mr. McClelland told Mr. Gibson that Mr. Allen was listed at the jail under a different name, stroke alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail, where someone from the Sheriff's Office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson the regular jail staff didn't know Mr. Allen was there. So God knows where they were keeping him. Like if the staff, like it's not that big, is it, the Carroll County Jail? If the staff didn't know that Rick Allen was being kept there, where on earth were they keeping him? Like in some hole somewhere. Still on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss his case over the phone because calls would certainly be recorded. At about 10 p.m. on October 27th, 2022, Mr. Gibson called Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day, Exhibit 1. All right, let's just go back here quickly to Exhibits 1C and 1D, just to take a look at those. I'm going to do this systematically and thoroughly. 1C. Okay. So this is Brad Rosie's affidavit here. I am a lawyer and practice in Logan Sport, Indiana, been a lawyer in good standing in Indiana since I was admitted to the Indiana bar June 7th, 2002. Since November of 2022, I've been the attorney for Rick Allen, as we all know, in an attempt to learn whether Richard Allen's first attorney, Brett Gibson, had communicated with either prosecutor Nick McClelland or then Sheriff Tobe Leesenby or any other law enforcement officer concerning the fact that he, Gibson, was representing Rick Allen effective October 26th. Well, it was actually October 27th. I reached out to Brett Gibson via email, asking him a series of questions. The purpose of my inquiry was to determine whether McClelland, Leesenby, or any other law enforcement officer was aware at the beginning, on October 27th, that should be, attorney Brett Gibson was representing Rick Allen after his arrest on October 26th. Attorney Gibson responded to my email inquiry and indicated that indeed Rick Allen had retained Attorney Gibson following Rick Allen's October 2026 arrest. A copy of said email, which is Exhibit 1D, is incorporated into this affidavit. Furthermore, in his email response, Attorney Gibson stated that he communicated with Nick McClelland both by email and by cell phone and alerted McClelland that he, Gibson, was in fact Rick Allen's attorney. There is no excuse for this. None. Furthermore, in his email response, Attorney Gibson stated that Prosecutor McClelland helped arrange a meeting between Attorney Gibson and Rick Allen at the Carroll County Sheriff's Office. Okay, let's look at the email between Brad Rosie and Brett Gibson. Okay. Hi, Brad. Attached is a letter I sent to the Carroll County Sheriff's Office and an email I sent to Nick McClelland on October 27th, 2022. Regarding your questions, did you ever communicate in any way with the prosecutor or any law enforcement officials before Rick Allen's arrest? No. Did you ever communicate in any way with the prosecutor or any law enforcement officials after Rick Allen's arrest? Yes. On October 27, 2022, Cassie notified me that Richard had been arrested. We sent a letter to the Carroll County Sheriff notifying them of my representation. The sheriff confirmed receipt over the phone. However, the jail advised that Richard was not an inmate. I contacted Prosecutor McClelland by email. He called me on my cell phone. He advised me that Richard Allen was in Carroll County Jail and they had him listed under a different name. He arranged for me to meet with Richard at the jail that evening. Someone from the sheriff's office took me to a meeting room in the jail. It appeared that regular jail staff did not know Richard was there. Let me know if you've got any questions. All right. So I think that's proof that Nick McClelland knew, Sheriff Leesenby knew that Rick Allen had an attorney. That attorney was paid for $5,000. So that would have been, all the initial dealings was paid for on October 27th, 2022. Unbelievable. Unbelievable. Shortly after his initial hearing on October 28th, Mr. Allen was whisked away from Carroll County Jail to the White County Jail without a safekeeping order authorising the transfer. So, to transfer anywhere to a different county jail or to a Department of Corrections, there has to be, you can't just take an inmate and move him. You can't just do that. But he was. On October 28th, he was just shipped off. Didn't tell anyone, just shipped him off to White County Jail. Why? Who knows? Then, on November 1st, 2022, a letter from Mr. Allen was mailed from White County Jail to the Carroll Circuit Court. The letter and the envelope are part of the record in this case. So we know what that letter is. That letter is, to the effect of, I didn't realise how expensive this was going to be. Can't afford to pay. Please get me a public defender. So obviously, once Rick Allen had been arrested for 2 counts of murder, Brett Gibson said, look, this is going to cost you, obviously told Kathy, this is going to cost you an absolute fortune. Therefore, you may want to look at, other options. However, on paper, Brett Gibson was still his attorney. Like Brett Gibson had been paid $5,000. So there's that. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. Okay, so that's interesting. And that might be where the confusion has come. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there and is shown filed in this court on November the 9th. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1st, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognised by the United States Supreme Court in Houston v. Lack, 1998, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. The safekeeping proceeding was clearly illegal from start to finish. First, Sheriff Leesenby transferred Mr. Allen to the White County Jail on October 28th with no safekeeping order in place, when the very day after, Nick McClelland and Sheriff Leesenby had correspondence with Brett Gibson, who was the paid-for attorney at that time. All right? So at that initial hearing, or whenever it was that Rick Allen was shipped off to White County Jail, Brett Gibson should have been involved in that. Next, Sheriff Leesenby had no standing to make the safekeeping request on November 3rd, due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28th. Once Mr. Allen was in White County Jail, the White County Sheriff was the sheriff, statutorily authorised to make a safekeeping request under Indiana Code 3533-11-1. Because Sheriff Leesenby had no standing to make the safekeeping request, Judge Diener had no jurisdiction to consider it. Because Judge Diener had no jurisdiction to issue it, the safekeeping order was literally void. And there was no attorney. There was no attorney. Like, Rick Allen, at this point, is now requesting an attorney of the court, who will now believe he's got no attorney, yet Kathy Allen has paid $5,000 to an attorney to retain him. So the correct course of action was to do nothing with Rick Allen until this was all sorted out. There should have been questions asked as to, well, you know, we've got Brett Gibson on file, Mr. Allen, as your counsel. Is he no longer your counsel? Do you now require, given that you've sent us this letter, do you now require us to give you counsel? Like, that should have been sorted out before anything else was done. Instead, during that week, when there was this turmoil between Brett Gibson and no attorney, he was transferred twice. He was transferred from Carroll County Jail to White County Jail illegally. And then he was transferred from White County Jail to Westville illegally. Unbelievable. And then Judge Dina promptly recused himself, just basically washed his hands of the whole thing, which is suspicious to me. Okay, second, Mr. Allen had the right to have a judge other than Judge Dina decide whether to issue a safekeeping order at Leesenby's request. And Leesenby shouldn't have requested a safekeeping, a change from White County Jail to Westville because Leesenby was not sheriff of White County. That was down to the sheriff of White County to sort out. If Rick Allen wasn't safe in White County Jail, having been transferred there illegally, the sheriff of White County should have been the one to contact the judge and say, look, we can't have him here for this, and this reason. We need to transfer him somewhere else. But nothing should have been done. Rick Allen should have still have been in Carroll County Jail whilst the issue of getting his counsel sorted was done. Absolutely outrageous. Outrageous. Okay. All right. This is because Judge Dina had engaged in ex parte communications with Sheriff Leesenby. Oh, is there any wonder why Judge Dina recused himself? So Judge Dina had engaged in ex parte communications with Sheriff Leesenby, helping Sheriff Leesenby draft his safekeeping request in violation of Rule 3.10 of the Code of Judicial Conduct, 2023. Rule 3.10 prohibits judges from drafting or reviewing documents except for family members. Judge Dina also violated Rule 2.9 of the Code by engaging in substantive ex parte communications with Leesenby, which helping Leesenby draft the safekeeping order certainly were. Having violated both Rule 3.10 and 2.9, Judge Dina was obligated under Rule 2.11 of the Code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd. So he went ahead and transferred Rick Allen to Westville and then recused himself. Not before liaising with Leesenby ex parte with no input from Rick Allen or his counsel, which was a question mark. You know, who was Rick Allen's counsel on November 3rd? Who was Rick Allen's counsel? Was it still technically Brett Gibson? Or was it no longer Brett Gibson? At what point did Brett Gibson leave? Unbelievable. So maybe Judge Dina knew that he'd made a colossal error and recused himself. Maybe Judge Dina was under pressure to get Rick Allen shipped off to Westville, and maybe he couldn't say no. Who knows? I don't know. It screams a setup. It absolutely does. It absolutely screams a setup. It absolutely does. See also Rule 2.11 of the Code. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Third, Sheriff Leesenby's November 3rd, 2022 request by the Sheriff of Carroll County, Indiana to transfer inmate from the custody of the Sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There's no certificate of service attached. Indiana Code 3533.11.1 requires a safekeeping request to be made by motion. Indiana Trial Rules 5A2 and 3 requires that Sheriff Leesenby's motion for safekeeping order be served on the parties. Because Sheriff Leesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for safekeeping order. So technically, Brett Gibson is still the attorney of record. Even if he claims Mr. Gibson was not representing Mr. Allen at this time, Sheriff Leesenby was required to then serve Mr. Allen personally. Because if he serves Brett Gibson and Brett Gibson says, sorry, you know, I'm no longer his attorney, and there's no attorney, well, technically, Rick Allen's pro se, like his own defence, until he's appointed a counsel, a public defender. So if Rick Allen served personally, Rick Allen, there should be a record of that. I mean, look, in my opinion, nothing should be done at all whatsoever until the question of who Rick Allen's attorneys were was sorted. But even if they absolutely needed to ship him off, they still should have served him, serve Rick personally, because assuming that Brett Gibson told them, but Brett Gibson nor Rick Allen, neither of them were served. So yet another breach. Fourth, Sheriff Leesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by Indiana Code 3533.11.1 that would authorize a safekeeping order. So they basically did everything wrong. And I don't think these people are stupid. I don't think they did this monumentally wrong just because. There's a reason for this. There's a reason why they all broke the rules. There's a reason why Judge Diener was liaising with Sheriff Leesenby ex parte without any correspondence with Brett Gibson or Rick Allen, that they just decided this on Rick Allen's behalf with absolutely no input from anyone else. They did it ex parte. Once he was shipped off to Westville, then the ink probably wasn't even dry. On Judge Diener's order, he recused himself. There's a reason for that. Fifth, because a factual finding was required to authorize the safekeeping order, a hearing with notice to the parties on Sheriff Leesenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had the absolute right to refuse being transferred to the custody of the department. Sheriff Leesenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only a defendant's personal safety, the defendant may refuse the transfer. But because Rick Allen wouldn't be aware of that, and Rick Allen was given no choice. Mr. Allen had no opportunity to exercise his rights to refuse the transfer to Indiana Department of Corrections custody or to make any of the objections set out above to the entire course of the proceeding. That is, that is for a quite simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary confinement at the Westville Control Unit, Wabash Valley Correctional Facility, and Cass County Jail for 23 months pending trial. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arguments that would necessarily prevented Mr. Allen's transfer. And if Rick Allen had never been transferred to Westville, he would never have been tortured, he would never have been psychotic, and he would never have confessed. Do you see where we're going with this? Finally, Mr. Allen's own absence from the safekeeping proceedings should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants with the same standards as trained lawyers. One consequence of this should be that the Sixth Amendment and Article 1, 13A of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of a criminal prosecution. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all the objections to the November 3rd safekeeping order set out above. Critical stage is one holding a significant consequence for the accused. Well, I think nobody can argue that shipping him off to Westville wasn't a significant consequence, because it sent him into a psychosis that, they needed that so they could work him, so that they could get him to confess. What was it that won the trial for them? It was the confessions. Unbelievable. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume Mr. Allen was prejudiced by that deprivation of counsel. Alternatively, Article 1, 13A of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. Section 13A affords citizens even greater protection than its federal counterpart. Not only does 13A guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but the rights afforded under Section 13 also attach prior to the filings of formal charges against the defendant. Where's this footnote? Where does that belong? Read this. The court need not speculate whether safekeeping proceedings have serious consequences for the accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconstitutionally kept in solitary confinement in an Indiana Department of Corrections prison, was shackled, leashed, and hooded, and deprived of human contact. Violation of due process for pretrial detainees to be kept in conditions amounting to punishment. That's Wolfish v. Bell. Okay. As a consequence of that torture, Mr. Allen became psychotic. Short of his death, it is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceeding. Couldn't agree more. Couldn't agree more. Dear me. Mr. Allen was not afforded either the right to be heard by counsel or by himself at a safekeeping proceeding. This should be particularly disturbing because he has been given the opportunity. Had he been given the opportunity to do so, Mr. Allen had an absolute personal right to refuse the transfer to the department. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. All right. That should be number 2. We've already had number 1. That's number 2. All right. So we now go on to Brad Webber. Now, this is another thing that, was very convincing for the jury, because it was Brad Webber's testimony of him driving by at like 2:25, 2:30, just in time for Rick Allen to get scared and then run the girls over to the opposite side of the creek and then kill them, both of them, before 2:32, when Libby's phone didn't move ever again. All right. Wow. There is absolute proof that Brad Webber did not pass by the bottom of the bridge on the south side where, according to the state's theory, Rick Allen was there essaying the girls or going to essay the girls, and it was Brad Webber passing by between 2:25 and 2:30 that scared him. There is absolute proof that did not happen. There's video. There is video of when Brad Webber arrived home. Kindness Cake, thank you for the $9.99. It is a travesty. It absolutely is. But thank you for your donation. All right. In violation of the Due Process Clause of the 14th Amendment and Neeg versus Illinois, 1953, that's no one, and its progeny, the state presented the testimony of Brad Webber, who lied under oath. Either he lied, the prosecutor lied, or they both lied. I don't know which. Okay, that Mr. Webber arrived home in his white van around 2:30 p.m. on February 13th, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. A conviction obtained through the use of false evidence, which this absolutely 100% was, the proof is here, known to be such by representatives of the state, shall fall under the 14th Amendment. The same result obtained when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. So either they knew about it and they did it anyway, or they learned about it after but didn't bother to correct it. All of those is a problem. At trial, the undisputed evidence was that Libby German's cell phone stopped moving at 2:18 p.m. on February 13th, 2017 for 7 minutes until 2:25. It then started moving again and stopped moving permanently at 2:32 p.m. In closing arguments that the jurors found so convincing, if we're to believe the juror that Murder Shits had on their show. And no, it's not my accent. Somebody asked me if it was my accent, of me saying murder shit, whether it's just my accent or whether I mean to say murder shit. Yes, I mean to say murder shit. I can say sheet. I can say sheet with my accent. My accent allows me to say sheet. I choose to use the word shit instead. Okay. In closing argument, Mr. McClelland called it a hard fact that Libby's phone stopped moving at 2:32. The state introduced an alleged confession by Mr. Allen by Dr. Monica Waller, a Delphi fangirl in all the groups, all the FB groups, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. In this alleged confession, Dr. Waller stated Mr. Allen said he had abducted LG and AW, Abby and Libby, on the south side of the Monon High Bridge and forced them down the hill to the south side of Deer Creek. Dr. Waller said Mr. Allen said he was on the south side of Deer Creek and was planning on sexually assaulting LG and AW when he was interrupted by a van. Dr. Waller said Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north, from the Webber property to Ron Logan's property, taking Libby and Abby with him. So if the phone started moving again at 2:25, you would assume that that's when Rick Allen got scared and made the move over to the other side of the creek. You'd think that, wouldn't you? I've told you. I told you based on Libby's movements, the phone's movements, that this theory was balderdash, that this theory did not work. Based on Libby's phone movements alone, the state's theory does not work. Well, if you didn't believe that, if you didn't believe me with that, well, believe me with this, because there's absolute 100% proof that Brad Webber did not drive by to his house at 2:25. There's absolute proof. The state also introduced the testimony of Brad Webber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 and arrived home in his white cargo van at about 2:30. But it must have been 2:25 because that's when Libby's phone started moving again. From Mr. Webber's testimony, the state argued Mr. Webber's arrival home in his van was what interrupted Mr. Allen, causing him to take Libby and Abby across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Webber's van about 2:30 was a detail only the killer would know, said the state. Even though I knew it, I knew 4,500 miles away. I'm still waiting for Nick McClellan to come along and arrest me as an accomplice because I knew that detail that only the killer would know. I bet many of you knew it as well. Anyway, we were told 3:30. Like Brad Webber and his mother were out and about in the Facebook groups early in the case, saying that he arrived home at 3:30. Well, that's wrong as well. So Brad Webber either had no idea what time he returned home, in which case he should have just said, "I've no idea what time I returned home," or he's lied twice. He lied then, and he lied under oath now. The problem is that the state also contended that Libby and Abby died near in time to 2:32 p.m. when Apple Health data from LG's phone showed that the phone stopped moving. If the arrival of Mr. Webber in his van interrupted Mr. Allen, forcing him across Deer Creek, Mr. Webber would have to arrive near his parents' house at the end of the private drive before 2:32. He'd have to arrive, like with the state's theory, he'd have to arrive at around 2:25 because that's when the phone started moving again. And arguably, according to what Rick told Dr. Waller, he moved them. He was going to essay them, so therefore that's why the phone was, stationary for 7 minutes. And then the movement of, them getting scared, is what created the phone to move again. I've told you that doesn't work. The state's theory does not work in relation to that Apple Health data. It doesn't work. It can't work. It 100% does not work. But this is the absolute proof that the state lied. And Brad Webber either lied or he had no idea what time he returned home. Okay. So he had to arrive before 2:32 when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Webber could not have arrived anywhere on the private drive before 2:44 and 54 seconds. His arrival at about 2:30 could not have been a detail only the killer would know because it didn't happen. It did not happen. The state knew or should have known as much. and the state either elicited Mr. Webber's testimony about the time he arrived home, knowing it was false ahead of time, or failed to correct the testimony once it had been elicited. This is how it gets good. Defendants Exhibit 3A, as attested to by Matthew Hoffman in Defendants Exhibit 3, is a video recording made on February 13th, 2017, by a security camera that was in the house at 5998 West County Road, 252 North. The video recording was provided to the defence by the state and has therefore been in the state's possession. The security camera faced west-northwest, and appears to have been recorded continuously. Based on the date and timestamps on the video, it appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. It's apparent due to the daylight and moonlight on the video and the associated timestamp. So whenever somebody set up the time, they've got AM and PM wrong. All right, we've all done it. The security camera had a wide-angle lens that captured video of traffic on West 252 North and County Road North 625 West. These are very confusing road names, I have to say. And the beginning of the private drive to the Webber property, which begins as a continuation of North 625 West, approximately 190 feet north of that road's intersection with West 252 North. County Roads North 625 West and West 25 North are the only roads in which a vehicle could enter the Webber property. According to the time and date stamps on the security camera recording, Exhibit 3A shows a white vehicle going north on North 625 West, entering the frame at approximately 2:44 and 33 seconds. Exhibit 3A also shows a white vehicle continuing into the private drive to the Webber property at approximately 2:44 and 54 seconds. Exhibit 3A is viewable on YouTube at the following address. Oh, State, what are you going to do? Shall we watch a little video? Oh, let's. All right. Let's watch a little video. Here we go. This is on Michael Osbrook's channel. I'll subscribe. He's got 44 subscribers. He's got 45 now. All right. So this is 8 minutes. And this shows the time. Okay. You can see that, can't you? 2:13, 2017. And then if we go... actually, this one doesn't show it. This is 2:45 and 19 seconds. It's the next one that shows it. Hold on. I'll put that in a new window. And then I can go back. Oh, what are you telling me? My file couldn't be accessed. Why? Okay, then. You're being annoying. Let me get it back. Boom. All right. Okay, what page were we on? Past that. Yeah. There. All right. I think the Exhibit 3B shows it, but Exhibit 3A is useful to show is that this is a continuous recording. It's a continuous recording, and there's no other vehicles that you see. Like in this 8.5 minutes, there's no other vehicles that you see. All right. But the next video is brilliant. The next video is brilliant. Let me show you this next video here. Exhibit 3B is a video file that contains 3 zoomed in clips from the video recording that is Exhibit 3A. Okay. Each successive clip in 3B is zoomed to greater magnification. In all 3 zoomed-in clips of Exhibit 3B, a white cargo van going north just after 2:44 and 33 seconds on February 13th is viewable on YouTube at the following address. Watch this. 2:44. Watch this. Watch closely. There it is. There it is. So 2:44. That's Brad Webber going home. All right, zoomed in a little bit better. There's Brad Webber going home. There he is. There's Brad Webber going home. So 2:40. He's going to have got home shortly after 2:45. So if you look at this one, it's like there. It's there. So you might be able to see it going up here, right at the beginning. Might have already passed by. Yeah, it's there. Maybe it's not. Maybe it's my eyes playing tricks on me. But anyway, there are no... Oh, hold on a minute. It's my eyes. I can't read. That's 2:42. I thought that's the 2:45. All right. 2:42. 2:44. Here we go. Here we go. So watch here. Watch here. There it is. There it is. There it is. There it is. So you should be able to get it through here. Yep, there. I just seen it. It's difficult once it's in the trees. There it is. Just left the shot there. So 2:45, and then you can't obviously see for that tree. There you go. That's Brad Webber returning home. So he either lied in 2017 and said he returned home about 3:30, or he had no idea. So just said, oh, about 3:30, but he had no idea. So it was honest mistake. Or he lied in at trial. He lied under oath at trial, or he had no idea. And he's been prompted by the state. You know, maybe they called him up and he said, look, I've no idea, honestly. I've no idea what time I returned home. And they said, well, could you have returned home around 2:25 to 2:30? And he might have said, yeah. It was probably about that time. So either could be possible. Either Brad Weber could have been told to lie, he could have been encouraged to lie, he could honestly believe that he was telling the truth. But one thing is 100% for sure, the state knew that this was a lie. The state knew it was a lie. Because if Brad Weber passes by here at 2:44 and he's home by, let's say, 2:45, 2:46. Is that his house there? Can't really tell. But if Brad Weber knew, if the state knew that Brad Weber didn't get home before 2:45, well, Libby's phone had stopped moving at 2:32. So according to the state's theory, Libby was already dead by the time that Brad Weber even passed by. So how can the state's theory be accurate, and how can Rick Allen's confession be true? Can't be, can it? 100%, that is the absolute proof that what Rick Allen said, and we have no idea what he actually said anyway, because Monica Waller might have just made it up because, that particular session wasn't recorded. Unlike practically every other time that Rick Allen had been talked to by anybody or was just in his cell, it was recorded permanently. It was recorded at every time. But this particular day, when he made this earth-shattering confession, it wasn't recorded. Isn't that just convenient? Isn't that just convenient? Yeah, very convenient. Very convenient. Okay, let's carry on. Exhibit 3C is a PDF with still photographs taken from Exhibit 3B at each magnification level. For each magnification level, zoom level 1, zoom level 2, and zoom level 3, there are 3 stills showing the white cargo van just before it passes the white sunlit house in the background on the west side of North 625 West, as it blocks the sunlit house, and 3 just after it passed the sunlit house. Reproduced below is the first still photograph on page 3 of Exhibit 3C, showing circled white cargo van before it passes the sunlit house. Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defence by the state and therefore has been in the state's possession. The photograph of Mr. Weber's white cargo van in Exhibit 3D appears to be at least similar to the white cargo van as it appears in Exhibits 3B and 3C, the zoomed-in video clips and zoomed still photographs created from Exhibit 3A, the original security camera recording. Let's look at those. Okay. Okay, Exhibit 3C. All right, so this is the zoom. There's the van. There's the van. We've all seen the van. We saw the van moving. And there's the timestamp. 2:44, 37 seconds. So it's going to be 2:45 by the time he gets home. Okay. All right. And this is Brad Weber's van. That's the actual van. Okay. That's the actual van. Oh, I'm not showing you. I'm not showing you. That's the actual van. So the stills. We've seen those. We've seen the van moving. We know that that is a van that looks very much like this van. Looks very much like it. Okay. All right. All right. Other video files produced by the security camera in the state's possession provided to the defence in discovery and covering the time from 2 p.m. to 4 p.m. on February 13th, 2017, does not show any other van driving north on North 625 West into the private drive to the Webber property. So at no point between 2 p.m. and 4 p.m. was there another van. There's no vehicles. There's no vehicles that pass by other than that one. So that has to be Brad Webber. He didn't arrive home at 2:25, and he didn't arrive home at 3:30. He drove on that road, caught by that camera, 2:44 into 2:45. Again, it's either Brad Webber's honest mistake that he genuinely didn't know what time he arrived home, but it's absolutely the case. It's absolutely the case that the state knew to the second what time Brad Webber's van passed by. And it wasn't 2:25, and it was after 2:32 when Libby's phone moved for that final time. Case closed. Case closed. Case closed. Well, let's carry on. Let's carry on. All right. Exhibits 3A, B, C reflect that if Mr. Webber returned home in his cargo white van, he could only have arrived home some minutes after 2:44 and 54 seconds. 12 minutes after the time the extraction of Libby's cell phone shows the phone stopped moving at 2:32. Either the white cargo van shown in Exhibit 3A, C, B, and C is Mr. Webber's, with him arriving home some minutes after 2:44, or it is not. In either event, no white cargo van or any other van entered the private drive to the Webber's property after 2 p.m. at or before 2:32. So if that one isn't Brad Webber's van, where's Brad Webber's van? So you either have to believe it's Brad Webber's van, and if you do, then he arrived home at like 2:45. So he arrived home after Libby's phone had stopped moving over on the north side of Deer Creek. Or you have to believe it wasn't Brad Webber's van. If so, where was Brad Webber and what time did he actually get home? Because there's no van that passes by on that road at all between 2 p.m. and 4 p.m. So if you want to argue that that wasn't Brad Webber's van, where was Brad Webber? Take your pick. Defendant's Exhibit 3E is a redacted FBI subject information sheet for Brad Webber, which is dated March 3rd, 2017. The unredacted version of Exhibit 3E was provided to the defence by the state and has therefore been in the state's possession. Exhibit 3E is the FBI subject information sheet for Mr. Webber. Says on 2/13/2017, Webber's phone pings to parents' address overlooking crime scene initially at 2:50 and repeatedly pings around the property until 11:55 p.m. So that fits with Brad Webber arriving home shortly after 2:45. So there's a phone ping at 2:50. So that's Brad Webber getting home and accessing his phone, which created a ping. So that fits. That fits. So that was Brad Webber getting home. That Mr. Webber's phone first pings to his parents' address at 2:50 is consistent with the video evidence in the exhibits, showing that Mr. Webber could not have arrived home in his white cargo van until sometime after 2:44 and 54 seconds. So let's take a look at Exhibit 3E. Here we go. Okay. All right, significant developments. So Webber has been staying at his parents' home in Delphi. The home overlooked and is adjacent to the crime scene. 202, time card, leaving Subaru, Indiana Automotive. 213, Brad Webber's phone pings to parents' address overlooking crime scene initially at 2:50, repeated pings around the property until 11:55, when presumably he went to bed or his phone died or whatever. So maybe they didn't even look for pings after that time. So basically that's the FBI ruling him out, isn't it? Or even keeping him in their sights, because at the time they didn't know what time the girls had died. So we still don't know what time the girls died. But yeah, subject information sheet, 3rd of March 2017. Okay. Moving on. From both Exhibit 3A, the security camera recording, and Exhibit 3E, the FBI subject information sheet for Mr. Webber, the state either knew that Mr. Webber's testimony about the time of his arrival home could be false before it was elicited, or failed to correct it once it had been elicited. When the state introduces testimony it knows will be false, or fails to correct testimony it knows it should have been known to be false, once elicited, a conviction must be vacated or reversed if that false evidence may have had an effect on the outcome of the trial. Mic drop. I'm speechless. I'm truly speechless. That is the mic drop moment. A conviction must be vacated or reversed if that false evidence may have had an effect on the outcome of the trial. We heard from that juror on Murder Shits that confession was important. That confession swung it. It was the thing that the only the killer would know. That was the gotcha moment from the state. Now that juror has come out and said that was important. A conviction must be vacated or reversed. So that's NAPU US 272, or see also United States versus Cardina 2016. To receive a new trial, the defendant must show 1, that there was false testimony, 2, that the government knew or should have known it was false, and 3, that there is a likelihood that the false testimony affected the judgment of the jury. United States versus Freeman, 2011. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Webber's testimony about the time he arrived home and used that testimony to corroborate Dr. Waller's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of Deer Creek and killed them. This was the only statement allegedly made by Mr. Allen that contained any detail of the murders that might be true. The state therefore cannot show Mr. Webber's uncorrected false testimony about the time he arrived did not have an effect on the outcome of the trial. Alternatively, were the court to find that the state did not know or should not necessarily have known about Exhibit 3A, even though it was the defense, it was the state's own evidence that they gave to the defence, the security camera video and Exhibit 3E, the FBI subject information sheet for Mr. Webber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's conviction or set this motion for a hearing. But there's more. There's more. Ron Logan's confession. We're going to get into that. Ron Logan's confession to Ricky Davis. So not only did Rick Allen confess whilst he was psychotic, not only did Elvis Fields confess, but also Ron Logan confessed. This confession's left, right and centre here. So the jury weren't allowed to know about the other confessions that people have made. Weren't allowed. All right. Ron Logan's confession to Ricky Davis before May 15th, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. So we're just going to throw this in. We're going to throw this in as a, just additionally. We're going to throw this in additionally. Dr. Court was the forensic pathologist who conducted the autopsies of Libby and Abby. His original opinion, held for years, about how Libby and Abby died was that two weapons were used, one a serrated blade and the other a straight-edge blade. For the first time at trial, having had a eureka moment at his tool bench, Mr. Court opined that the girls could have been killed by a single box cutter rather than two different knives. Defendant's Exhibit 4A, as attested to by Matthew Hoffman in Defendant's Exhibit 4, is a redacted copy of a tip from the Orion database of tips dated May 15th, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Ricky Davis sometime before May 15th, 2017, while they were in prison together, that he had killed Libby and Abby. The material part of Ron Logan's confession to Ricky Davis, as it appears in Exhibit 4A, is reproduced below. So Logan confessed to Ricky step by step of killing the two girls. Logan told Ricky how he burnt his clothes in a fire pit and where it was located, used box cutters, and struggled with one of the girls and thought drops of blood from his nose ended up on her clothes. Ricky also advised that he killed the older girl first, so Libby. Okay. Ron Logan's confession to Ricky Davis, as reflected in the tip in the Orion database and made a mere 3 months after the girls were killed, was detailed. Law enforcement followed up on that tip. Defendant's Exhibit 4B was attested to by Matthew Hoffman in Exhibit 4. Accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant P. Hansard about his interview with Ricky Davis on June 21st, 2017 at the Newcastle Correctional Facility regarding Ron Logan's confession to Ricky Davis. Those handwritten notes of First Sergeant Hansard are attached to Indiana State Police Detective N. Wolf's lead narrative summary cover sheet, as it was provided to the defence in discovery. First Sergeant Hansard's notes of his interview with Ricky Davis about Ron Logan's confession provides even more detail. Hard as they are to decipher and subject to debate and correction, those notes reveal the following about Ron Logan's confession to Ricky Davis, page 1 of Exhibit 4B, as reduced below. All right, let's just have a look at Exhibit 4 before we look at that. All right, so I'm the investigator. So this is Matthew Hoffman, who has worked for the lawyers representing Richard Allen. Included in the discovery provided by the state to the defence was a tip regarding Ron Logan's confession to Ricky Davis. Tip was in Orion. Exhibit 4A is a redacted version of that tape about Ron Logan's confession. I've reviewed the original tip and compared it with the redacted tip, that is Exhibit 4A. Exhibit 4A is a true copy of the original tip with only the personal information of the person who provided the tip, sensitive details about the coverage of the lead redacted. 4B accurately reproduces the handwritten notes taken by Indiana State Police Sergeant Ansard. Okay. All right. So I'll have a look at Exhibit 4A. Exhibit 4A. Okay. Narrative. So this is what's in Orion. Ricky Davis is currently incarcerated at the Newcastle Correctional Facility. Blank received a call from Davis advising he is in the same block as Ron Logan, owner of the land and where Delphi homicides took place. Genrich reported Logan is in prison on parole violation. Logan confessed to Ricky step by step of killing the two girls. Logan told Ricky how he burnt his clothes in a fire pit where it was located, used box cutters, and struggled with one of the girls. Thought drops of blood from his nose ended up on her clothes. Why was his nose bleeding? Did like one of the girls hit him or something? Hopefully. Ricky also advised that he killed the older girl first. So that's the tip. Oh, look. Lead is discontinued due to no follow-up with Ricky Davis. Ron Logan passed away January. Okay. All right. There's no way. There's absolutely no way that I can read that. No way. It seems to say, talking about knowledge, one of the dads, knowing one of their dads, to walk with them. One of them wanted to turn around, grabbed youngest shoulders. It's okay. Oldest freaked out. One said something about calling police. Sexual attack wasn't true. Originally not trying to go rape them. Paranoid about probation. Felt like he crossed line when he grabbed the youngest one. The top half of page 2 of Exhibit 4B is reproduced below. The bottom half duplicates the top half. It seems to say he started talking, ironic, should have been in school. Knew one of their moms, waitress at a bar. Animals, walked with them, willing to go check out horses. And he told them he had rabbits in barn, walked through trailing woods. Oldest paranoid, didn't want to go. Youngest wanted to see horses. Top half of page 3. Seems to say oldest turned to help youngest. Oldest started looking kicking. Probably kicking. Youngest seemed, he now grabs oldest. He said he got hit on nose, scared he got blood on one of the girls, pulled box cutter out, slit oldest, hit an artery. Youngest scared, etc. Took little girl with him for a while, never said where, said he cut her to cut both necks. Wow. Shit. Shitting hell. Could it have been Ron Logan all along? Seriously? That's pretty freaking detailed. The bottom half of page 3 of Exhibit 4B is reduced below. Seems to say, he left again, came back later in evening, search going on. Later, on late hours, tried to move oldest one to area not going to be found. Place where four-wheelers go. Burn disclosed on burn pile. Hiking, walking boots, gloves, bag. Soles of boots, something in burn pile. Next morning, 2 other girls knocked on door, asked to search on property. Felt weird if he said no. He let them take off, got a hold of family members and got out of area. First time he's seen them on property, home, etc., guns, etc. During struggle, youngest girl, something happened to friend to stand there, head, neck, artery. I don't know what to say, honestly. I don't know what to say. If only that was better written. Defendant's Exhibit 4C is a handwritten note signed by Ricky Davis, dated June 21st, 2017. The same day, First Sergeant Hansard interviewed him. That handwritten note is attached to the same lead narrative summary cover sheet and is contained in the same file as First Sergeant Hansard's handwritten notes that are Exhibit 4B X4. Ricky Davis's handwritten notes about Ron Logan's confessions to him says, Mr. Logan made reference to killings in Delphi, Indiana. He told me he was the one who had killed those girls that got out of hand. He walked with them in the woods to his property and the girls wanted to turn back. Said something about walking there, something. He grabbed the youngest girl to reassure her it was okay. However, they panicked and he also panicked. He indicated he ended up cutting the eldest with a box cutter. He went on telling me that he killed both of them because it was took too far. So he's panicked, slashed Libby's throat. She's bleeding out. Now he has to kill Abby. But how come Libby was naked then? What's all that about? How come Libby was naked and Abby was dressed in Libby's clothes? That doesn't make sense. Why was Libby naked? I bet Nick McClellan wishes he didn't bring up box cutters now, though. Seeing as it's been in the discovery all this time that Ron Logan confessed to killing them with a box cutter, I bet Nick McClellan wished he'd kept his mouth shut about box cutters. Staged. Yeah, it could have been. To make it look staged. To make it look like it had been a sexual attack. Possibly. What was the date of the handwritten note? The tip was made. On the 15th of May, 2017. So that's when Ricky Davis called in the tip. And then he was interviewed by the cop. It does say June something. June 21st, 2017. So Exhibit 4B, as attested by Matthew Hoffman, accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant P. Hansard about his interview with Ricky Davis on June 21st, 2017. So Ricky Davis calls in the tape May 15th, and it takes them over a month to interview Ricky Davis about a tape that comes from the person whose land the girls were found on. It took them a month. Okay, great. Great, fantastic. 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 Okay, so we've read that. So in addition to the other details that fits the known facts, Ron Logan confessed to Ricky Davis that he used box cutters to kill the girls. If instead of, for the first time, Mr. Allen's trial, Dr. Course said 7 years earlier that the girls could have been killed by a box cutter, there would certainly have been probable cause to arrest and charge Ron Logan with the girls' murders. There absolutely would have been, because that contains details that only the killer would know. Surely. As it was, the FBI, 2 months before Ron Logan's confession to Ricky Davis, had obtained a judicial finding of probable cause to search Ron Logan's property. Under the circumstances, Dr. Core's trial testimony about a box cutter possibly being used to murder the girls makes Ron Logan's confession to Ricky Davis newly discovered evidence that would either be admissible through Ricky Davis under Evidence Rule 804 or through First Sergeant Hansard under the Due Process Clause of the 14th Amendment. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at a retrial. Accordingly, the court should either vacate Mr. Allen's conviction or set this motion for a hearing. I bet Nick McClelland is sick right now. I bet his head is right down the bog bowl and he's retching his guts up. I hope so, anyway. I hope so. We got more. We're nearly there, but we got more. Defendants Exhibit 5, the affidavit of Stacey Eldridge, states that dirt or water damage to the phone could not have caused the auxiliary jack on Libby's phone to log wired headphones plugged in and wired headphones unplugged. Miss Eldridge's expert opinion is newly discovered evidence that would probably produce a different result at a new trial. So I did a video saying that iPhones, including the iPhone 6S, contains a sensor that comes on when a phone is water damaged. I did a video about this, and it's true. Yet another thing in my videos that's true. Whoa. All right, at trial, Mr. Allen introduced evidence through the testimony of Stacey Eldridge, a digital and mobile forensic expert. She worked with the FBI, so she knows the stuff. That someone plugged wired headphones into the auxiliary jack of Libby's phone at 5:44 p.m. on February 13th, 2017, and unplugged it at 10:32 the same day. To counter this, the state offered the results of a seat of the pants Google search by First Sergeant Cecil, the state's phone expert. According to First Sergeant Cecil, the Google hearsay told him. I do love these little snippets of sarcasm in the defence's filings. I love them. The state's phone. According to First Sergeant Cecil, the Google hearsay told him, in his expert opinion, in Google's expert opinion, the log on Libby's cell phone showing wired headphones were plugged in to the auxiliary jack at 5:44 p.m. and unplugged at 10:32 p.m. that same day could have been caused by dirt or water damage to Libby's phone. The defense had no opportunity to counter First Sergeant Cecil's expert opinion, courtesy of Google. The court should read Miss Eldridge's affidavit, Exhibit 5, in its entirety, but the short version of her actual expert opinion is. Now we're going to read the full version. I'm going to read the full version here. All right, we're going to read the full version. Oh, I haven't been sharing the right screen. I apologize. But I promise you that I've been reading it correctly. But we've got Exhibit 5 here. Eldridge's affidavit. Okay. Comes now the affiant Stacey Eldridge under pain of penalty of perjury. States the following: over 18. Receive my bachelor's of science, blah, blah, blah. Receive my master's. Provide digital forensics and mobile forensic services through my business. I am an adjunct professor at Oklahoma State University. I'm also an adjunct professor at Bellevue University and teach cybersecurity and digital forensics. I was the director of cybersecurity. All right, so this is just a... All right. Certifications. I don't need to read any of that. Okay. All right. Data from Liberty German's iPhone 6S showed that wired headphones were plugged into the phone at 5:44 Eastern Standard Time and were unplugged at 10:32 p.m. on February 13th, 2017. This was the only evidence of any wired headphones ever being plugged in and removed from the phone. Apple iPhone 6Ss were equipped with sensors to indicate water damage, as I told you in my expert opinion that I found on Google. There was no indication in the data from Miss German's iPhone 6S that indicated the sensor identified water damage to the phone. I would expect to find evidence of the water damage notification that is displayed to the user to be present on the iPhone. I reviewed the following extractions and reports produced by the state of Indiana in discovery of this matter. Celebrite Logical Extraction Report and data created by Brian Bunner on February 15th, 2017. Okay, another one by Brian Bunner on October 12th. This is why the Knowledge C database was wrecked, because they did all of these different extractions. All right, so then we've got Cecil, October 21st, 2019, and then Cecil again on August 18th, 2024. So she reviewed all of that. None of the above reports, and you would think that at least one of these reports would have picked up the potential that the sensor had been triggered to indicate that the phone was water damaged. None of the above reports or extractions contain evidence of dirt or water damage to Libby's iPhone 6S, nor did they indicate that it was particularly dirty or covered in debris. I reviewed photos of the phone taken by Indiana State Police. The phone does not appear to be wet, dirty, or covered in debris in any of the pictures. No pictures were taken of the phone displaying a message indicating that liquid had been detected. No pictures were taken of the control center of the iPhone to document that headphones were being reported as being plugged in when they were not. I reviewed the chain of custody for Libby German's iPhone 6S, and it did not document that it was received in a wet, dirty, or damaged condition upon receipt. iPhones that have had recent water damage are known to reboot spontaneously, requiring multiple attempts to complete the extraction with a forensic tool. No instances of this were documented or reported by the Indiana State Police. I am currently unaware of any scientific or technological research suggesting that water or dirt damage of an iPhone 6S will cause the phone to inaccurately log wired headphones in or wired headphones out. And if there was water damage that did influence the headphone jack, there should have been an indicator in the extraction that that sensor had been triggered, and there was none. Okay. According to the Apple Health data on Libby's iPhone 6s, the phone stopped moving at 2:32 on February 13th. At trial, the state contended Libby and Abby died close to that time, and Abby hid the phone under her body before she died. You know, the hero that as she was bleeding out, she hid the phone under a shoe under her body, like you do when you're bleeding out. Not that you're completely panicking, that you're dying. No. You think, oh, at some time in the future, this phone is evidence. Therefore, I'm going to hide it under a shoe under my body. The state also provided testimony by former Delphi Police Chief Steve Mullin and Indiana State Police Lieutenant Jerry Holman. There was no evidence that Richard Allen returned to the location where the bodies were found, allegedly being spotted by Sarah Carbo at approximately 3:50. It's actually, was it 3:57, 3:56, 3:57. If Miss Eldridge's actual expert opinion that wired headphones were plugged into Libby's auxiliary port at 5:44 p.m. and unplugged almost 5 hours later were credited by a jury, the state's narrative is impossible. Someone other than Richard Allen was handling Libby's phone multiple times long after the state contended Mr. Allen left the scene before 4 p.m. on February 13th, 2017. Miss Eldridge's opinion that dirt or water could not have caused Libby's phone to log wired headphones being plugged in and unplugged from the phone on February 13th exculpates Mr. Allen and would probably produce a different result at a new trial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. The matters set out and attested to above, taken individually or cumulatively, entitle Mr. Allen either to have his convictions vacated or to have a hearing on those matters set. For the foregoing reasons, Mr. Allen respectfully requests that the court either vacate his convictions or set the matters above for hearing, and for all other just and proper relief in the premises. Andrew Baldwin, Jennifer Auger, and Bradley Rosie. There you go. There you go, guys. Let me just see if there's anything else in the files here that we've not looked at. Let's take a look. We've got this abstract here. Motion to correct. Oh, this is interesting. This is interesting, little aside. Defendant Richard M. Allen by counsel respectfully requests that this court issue an amended abstract of judgment. In support of this motion, defendant states the following. On December 23rd, 2024, this court issued an abstract of judgment in this case. Under Part 4 of the form, the court indicates that there were no mental health concerns with the defendant. Okay, well, all right then, eating your own feces is perfectly normal then. And prison cured Richard Allen's lifelong depression and anxiety. Can you believe that? If you can believe that, what Judge Gould wrote on December 23rd, 2024 is effectively that prison has cured Rick Allen of his lifelong depression and anxiety. Who'd have known? At trial, evidence was presented that the defendant had significant mental health concerns throughout this case. Dr. Waller, Dr. Martin, Dr. Westcott all testified about defendant's mental health issues. Video evidence revealed behaviour by defendant while awaiting trial that raises concerns about his mental health as well. Providing accurate information on the abstract of judgment is critical to ensure the Department of Corrections is aware of defendant's mental health issues so that defendant will receive continuity of care and appropriate placement, effective treatment, medication, etc. So So Judge Gull has effectively told the Westville that Rick Allen has no mental health concerns, so he's not going to be on medication, is he? They're not going to be treating him for depression. He's not going to be on any medication. That's for a reason. That's for a reason. This is insane. This is insane on so many levels. I think we've seen everything else. So that's just Baldwin's appearance for being filed. We've seen Gibson stuff. We've seen 3B, 3C, 3D, 3E. We've seen 4. We've seen 5. We've seen that. What's this? Oh yeah, that's just the video stuff, the file names and stuff. So I think we've seen it all. Yeah, that's just talking about the files. All right, we've seen it all. There you go. Now that is some spectacular. That is some spectacular work by the defense team. Yet again, they pull it out the bag. This insane case. Any other case would have been thrown out by now. Look at Barry Morphew. They had way more evidence against Barry Morphew. Barry Morphew was headed to trial. They were almost there at trial. And the prosecution decided to pull it at the last minute because they didn't feel that the evidence was strong enough. And they had tons of circumstantial evidence against Barry Morphew, arguably a much stronger case than what the state has against Rick Allen. And yet Rick Allen has now been convicted of 2 murders of 2 little girls, and his life is completely ruined. And the only way that the conviction was gained was by lies. Deceit, and all of this is slowly unraveling. All slowly unraveling. Which video? You must have come in later. This video. Brad Webber's van. Hold on. Let me... Brad Webber's van coming home. Not at the time when the state said it did. You can see here 2:44 and 34 seconds. And you see Brad Webber's van. This is the road leading up to. This is a private drive. There's his van. There it is. Leading up to his house, which is somewhere along here. You see it pass by. Your eyes start playing tricks on you when you're looking in the trees. But there's a zoomed in version here. Watch this. There's Brad Webber's van driving by at 2:44. So he would have got home 2:45, 2:46. There's his van. Not 2:25 to 2:30 that the state had him testify to. There's his van, and it's the only van to drive by on that road at all between 2 p.m. and 4 p.m. So that has to be Brad Webber's van. Boom. That is such... I mean, look, there's no way that conviction can stand. No way. Just those things alone surely vacate that conviction. Surely. Anyhow, there we have it. Let's see what fallout comes from that. If Judge Gull says denied without hearing, I'm going to absolutely lose my shit. I'm sorry, I will. I'm going to lose my shit. What happens now? Well, either the court has to vacate his conviction or set this for a hearing, and the state needs to answer to these claims. The state needs to answer to each and every one of these claims. That's what happens next. That's what should happen next. Whether it will happen in this case, anybody's guess. Anybody's guess, but that's what should happen next. And there's no way that she's going to vacate. There's no way she's just going to say, oh, okay then, you know, Rick, you can go, see you later, bye-bye. But there should be a hearing in which the state answers to each and every one of these points. That's why I believe Nick McClelland right now has got his head down the bog bowl and he's retching his guts up. Or at least he should be if he had any ounce of empathy or anything. I'm sure he's got self-preservation. So for that reason alone, he's going to be feeling very sick right now. So let's wait and see, shall we? Let's wait and see. All right, guys. So for the second time today, thank you for joining me. Thanks, as always, to the mods. And thank you to those that donated earlier on in the live stream. It's very much appreciated. And hopefully, things will settle down for the rest of today. And I can go back to watching Netflix. But I shall see you tomorrow. Bye, guys.